to welcome Professor Erin Delaney to speak to us today. She is Professor of Law at Northwestern University Pritzker School of Law. She also has an affiliated position at the Department of Political Science there. Most importantly of all, she is a centre member. She is a member of our centre and also of the Keith Forum. So we are delighted to have you speak to us. She's going to speak on the federal case for judicial review, and our discussions for the paper are Professor Stephen Tierney, who is Professor of Constitutional Theory here at the law school, and then Professor Neil Walker, who is Regius Professor of Public Law and the Law of Nature and Nations, also here at the law school. So the way it will work, Professor Delaney will speak for a while on her paper, then we'll get the comments from the discussants. We'll go back then to Professor Delaney to see if she has anything she'd like to respond immediately to these comments, and then we'll open up the floor to questions from all participants and then to the discussion. So without further delay, Erin, the floor is yours.
Thank you. Thank you very much, Alessandra, and thank you, Sangha, for inviting me, to Prevar for organizing, and obviously Stephen and Neil for agreeing to comment and putting me through my pieces. It is hard to say anything positive about the past year, given the ongoing destruction that COVID is wreaking around the world, but the facility with technology is some positive, and I feel incredibly fortunate to be able to continue my visit at Edinburgh. My time as a McCormick Fellow was one of the most fun and productive visits that I've had, and so it's great to be able to recapture it through these Zoom meetings this year. So I'm very grateful for continuing to be a part of your scholarly community. So a few words, for those of you who don't know me, I've been interested in the role of courts in federal systems for a long time. In my PhD dissertation, I looked at the role that federal courts can play in shoring up the political structures of federation. And then after law school, when I was introduced to the debates over judicial review, I started thinking about the interactions between judicial review and federation. And I wrote about the ways in which federation shores up the power of apex federal courts. But in all of this structural discussion, as is typical in this little slice of political science and law, there's not a lot of focus on rights review. So turn then to the canonical article on rights review by Jeremy Waldron, the core of the Case Against Judicial Review, which has in many ways set the academic agenda in this area for over a decade, and which I think continues to influence real-world constitutional and political debates, or at least the Judicial Power Project at Oxford. In his article, Waldron constructs a set of rosy assumptions against which backdrop he evaluates whether courts or legislatures are best placed to conduct rights review. His stated assumptions include a functioning democracy based on principles of political equality, in which participants have a commitment to rights and yet disagree about their application and content. In this system, he concludes that legislatures are more able than courts to reflect his democratic process-based metric of evaluation, the quote, equal voice and equal decisional authority of citizens, close quote. In his article, he flags that his theory should have resonance for the UK, which I think it has had, New Zealand, and Canada, the United States, and Australia. But he ignores what I think is the key structural distinction in those latter three countries. They are all federations. The Cork case reflects the feature of a governance system with a unitary state. But what happens if you start to think seriously about the role of a federal apex court in rights adjudication? And so that's what I would like to do today. The essay that, if you haven't had a chance to read it, it's a thought experiment And I suppose that one payout of it is just highlighting the many areas that need more scholarly attention, right? Federal democracy, is that a contradiction? The tension between federal variation and individual rights protections, the role of a federal legislature, expectations of a federal court. There's plenty of work to be done. And as I say in my conclusion, right, the future is federal, or at least it might be. I recognize it's complicated in the UK right now. So in the talk, I want to quickly walk through two key differences between federations and unitary states that I think complicate Waldron's analysis and change the metric for evaluation and, frankly, our understanding of rights definition. I then will very briefly review the comparative institutional analysis that I conduct, and in which, to save you the uncertainty, I conclude that a federal apex court should be considered presumptively better than a federal legislature at conducting rights review. A presumption, of course, that could be rebutted in a particular context, but I think shifts the balance back to courts. So a few throat clearing preliminary issues, if I haven't done enough throat clearing already. Like Waldron, I too am using a stylized approach. So my stylized federation is heterogeneous, cross-cutting social cleavages. So in other words, national minorities are not arranged as territorial majorities in subnational units. In other words, you don't have all of the French-speaking unit necessarily in one province. So Canada presents, is in some ways core, in some ways outside, right? This is stylized. I'm assuming symmetrical federation in which no one subnational unit has an outsized sway. And basically in these contexts, what I'm trying to do is to avoid a situation where there's already specified protected group rights and a baked in role for an apex federal court. So these latter types of federation would fall outside this core case. And I talked about them a bit in my conclusion, and we can talk about them in the Q&A. In some ways, that's the core direction that federation is going. So I recognize that I am also open to the critique of how many really existing examples of my stylized federation are there in the world. The other point about my federation is that its subnational units have a substantial measure of autonomous governments. So I'm not envisioning a system of decentralization, but one of more classical federation, so that the states have governance authority and the state population, the land population, functions really as a subnational demos for a set of issues. So once you have that stylized federation on the board, the differences between the unitary state and a federation are quite, I think, pertinent. So due to the semi-autonomy of these subunits, right, there are in fact multiple demoi within the polity and multiple levels for decision making. And these facts impact Waldron's assumptions in two critical ways. First, his democratic metric for evaluating on process-based reasons the relative capacity of legislatures and courts doesn't apply. A federal legislature doesn't embody the citizens' equal voice and equal decisional authority established through majoritarian decision-making. Any stylized federal legislature is bicameral. In fact, all federations, actually existing federations, have bicameral legislatures. And the second chamber in my stylized version represents the component states, not individuals. And this pertains in almost all actually existing federal legislatures around the world. And even in those second chambers that don't include representatives of the state qua states, so actually like the Bundesrat or the 1789 US Senate, where there's real state representation, population differentials mean that the second chambers are really never equal unless you can ensure, population equivalence across subunits. So in the United States, a Wyoming voter has over 68 times the weight of a voter in California in our Senate. So then the question that I pose in the paper, what do we do? Do we just say, okay, forget it? Or can we come up with an alternative metric that might work to do this kind of evaluation? So I could shift completely away from majoritarianism. So we could turn to just a different kind of democratic metric, like democratic deliberation or republicanism. Even here, these theories and their relationship to federalism hasn't been fully explored. And federal scholars do assume or accept that some kind of majoritarianism is at play in federal governance. But there are multiple majorities. So what I do for the purpose of this paper is I propose a federal democratic metric. And so rather than asking which institution gives equal voice and equal decisional authority to individuals, I ask which institution is able to give equal voice and equal decisional authority to the multiple demoi of the federation. So which institution can take into consideration the multiple majorities inherent in a federation? The second point I think that's important about shifting to federation from a unitary state actually comes into the question of the rights analysis itself. Federation actually presupposes the kind of reasonable disagreement about rights that Waldron assumes. That could be part of what's driving the federal construct. So I suggest that in a federation, you must not ask not only what is the content of the right, and that's the question Waldron poses to his legislature and his court, but also at what level should the right be defined and protected. So rights in federations actually have a dualist rights structure quality. And in the paper, I give a variety of ways in which this duality gets actualized based on an individual system's underlying rights architecture. How do the multiple majorities feed in to these questions, both of definition and of level of right, definitional level, whether a subnational or national majority. So in addition, I argue that federation introduces an inherent instability that makes it even harder to escape this duality. So drawing on the work of Giora Binder and others, I suggest that rights issues, due to their moral nature and the role of universalist theories of individual rights, necessarily result in a centripetal force. So contestations are pushed to the national level. Advocates seek all or nothing solutions, right? They seek uniformity of treatment. This idea that you can't have variation from postcode to postcode, right? At the same time, right, as there is this expectation of variation and the existence of autonomous governance at the subnational level means that minority interests can reopen and re-engage apparently settled determinations. The United States is a great example of this with our back and forth on the death penalty, right? Where you see states pushing the federal government, the court and the legislature to change views on the death penalty or to push back against what appears to be the national consensus. Clearly, it's happening in the area of abortion rights right now as well. So this pressure for nationalization, I think, adds a nuance to the federal democratic metric in the context of rights. I think it's not only therefore a question of which institution can better take into account the multiple majorities inherent in federation, but also which institution is best placed to withstand the dangers of over-centralization of rights in a federal system. And so once I've done all this background work, right, the final portion of the paper walks through the comparative institutional analysis, addressing these process-based metrics. And I conclude, as I said before, that a federal apex court is the institution presumptively better placed to resolve this duality of rights definition and articulation. So just a couple of brief arguments here, and then I will conclude. So take first the legislature. We've already talked a little bit about what a federal legislature looks like. It's likely to be bicameral. That's what I propose in the paper. But is it within a parliamentary or a presidential system, what I'm calling presidential, but I mean sort of American style legislative system. So I walk through these different options in the piece, and I conclude that the best case for the legislature is to be a non-parliamentary legislature with decentralized parties. That is going to get you closest to taking seriously the duality of the rights construct in the federal system. But even here, and I draw on Jenna Bednar's work, I think that there's a high likelihood of policy centralization due to the way in which electoral incentives operate in conjunction with shared jurisdiction and jurisdictional overlaps. The opportunity for gamesmanship creates incentives for overreach. So in summary, I think in all federal legislatures, federal legislative action ends up being a function of constituencies, electoral rules, preference aggregation through party mediation that operates against a backdrop of divided and shared powers leading to gamesmanship. Ultimately, I think these factors create asymmetric constraints for legislators. They are more constrained by the national majority than they are by subnational majorities. So this is a pressure that would only be increased in the rights context. And it's hard to define many countervailing forces. In the apex court, right, again, there are challenges of articulating institutional design. In this case, I try to figure out, well, what's the most difficult design? So I've tried to give the best possible case for the legislature. Well, what's the worst possible case for the court? So I don't assume any sort of specific subnational representation on the court, or even a role for the federal chamber of the legislature in the selection process. You could imagine sort of putting these institutional design elements into the court construct that might further help the court be attentive to multiple majorities. But I don't. There's no clear argument that courts themselves drive centralization. I mean, people argue it, but there's no clear evidence. It's a contested topic in actually existing federations, but it's uncertain. There are lots of arguments. It does seem that centralization occurs over time. It's not clear that it's due to the court. But even assuming some of this centripetal pressure, there are institutional aspects of the judiciary that push back against the centralization. And I think there are two critical ones. The constraint of the judicial method, which, unlike many political scientists, as I am also a lawyer, I take doctrine seriously. I think the law does matter. And legitimacy concerns. So to take the constraint of the judicial method first, I suggest that the role of judicial reasoning makes it more difficult to use subnational autonomy as a political value that can be traded off against other goals. So I think it forces reckoning with subnational interests in a way that it does not in just political articulation. And this is because I believe that doctrine has bite and that it is harder to write yourself around doctrinal constraints than it is to argue around them in a legislative context. More importantly, or in addition, I think that the court has a more dramatic need perhaps for sociological legitimacy within a federation. So compliance, which is a measure of sociological legitimacy for a court, I think that's more challenging in a federation than in a unitary state. For reasons that I alluded to earlier, right? Semi-autonomous subunits have a greater capacity to dissent in highly effective ways. And the universality that drive rights claims can also engender backlash. So an apex court will have to tread carefully, and it will need support from the central government, but that support is highly contingent. I think this suggests that a court must be attentive to multiple majorities. And I think there's evidence in actually existing systems that these pressures do affect decision-making, sometimes leading courts to avoid contentious rights claims or even to monitor and mediate political engagement. I think the broader structure of a federal judicial system can further compound these institutional weaknesses depending on how the apex court is situated, whether it's an integrated system or a dual judicial system with separate courts. So Waldron recognizes these institutional pressures that apply to courts, and he highlights them as a reason that undermines the ability of the judiciary to engage in principled reason giving on rights questions. He says because the courts are distracted by legitimacy, they can't get to the heart of the substantive matter. And this may be so. He may be right about this, but I don't think that changes what is his ultimate conclusion in his piece, that he's unable to say which institution would be likely to be better on the substance. Neither institution is immune from the influences that can pervert substantive decision-making. I think, as my colleague Joy Milligan has argued about the United States federal legislature, each problem that the court's critics diagnosed in the judiciary can also be seen in that legislature. So I'm not sure that it changed, that there's anything to be said about the outcome reasons. And I continue sticking to process-based reasons in my own piece. It does raise real questions about some of the normative goals of liberal constitutionalism and the idea of courts, right? Can they really be counter-majoritarian institutions? Maybe even less so in a federal context, although we've seen fairly unsuccessful courts in unitary contexts as we see the retrenchment of rights and the rise of populism in Poland or Hungary, places like that. So I'm not sure that this paper has anything to say about aspirations, counter-majoritarian aspirations for the future of courts. But I do think it has to say that a federal apex court plays an important role and should play an important role in rights adjudication in a federal system, and that it may very well be the best place to handle this duality within a federation, accepting, as I note, right, that I'm taking for granted sort of the teleology of federation itself as something that is important to foster and continue. So this again, I think, complicates our conversations about the normative goals of structured governance, and that federation adds something to democracy and adds a complicating element. So with that, I will stop. I look forward to comments, questions, and our general conversation. And so thank you all very much for being here.
Sorry, I didn't realize where the music was coming from.
The timing was perfect, though. Thank you, Neil. It was awesome.
Thanks very much, Erin, for an excellent paper. I'm sure people have a lot of questions and comments, but I'd ask you to save them because I'll hand over to Stephen first for his comments.
Yeah, fascinating paper, Erin. And I think that point you finished on, the teleology point, really goes to the heart of some of the things I'd have to say. I think you're opening up two seams of research here, in the best tradition of opening a new area of research. One is theoretical and one is empirical. So I'll say a little bit about both, but I find the theoretical questions that you're raising particularly interesting and challenging. I mean, notable, you begin from the premise that federalism is incredibly under-theorized, both within political philosophy and constitutional theory. And from then you move to look at Jeremy Waldron's discussion, why should I accept a decision with which I disagree? And then the sort of equal voice, equal decisional authority argument that he puts forward, and the assumption that a legislature is best placed. From there, I think your really interesting point is, this idea that federalism necessarily qualifies and complicates majoritarianism, and that this raises questions about the democratic value of a legislature in providing an equal voice. So I think in raising this as a starting point, and although your paper is targeted on the issue of rights, you're actually, I think, introducing very wide-ranging and important questions about the very nature of federal constitutionalism that in fact transcend the rights debate, and I think actually complicate the rights debate greatly. It seems that what you're doing, no less, in bringing together the notion of democracy and democratic consent in a federal context, is bringing to the fore the nature of federal subjects and the fact that within federalism, subjecthood is about territory and not just individualism. And arguably, it's the territorial nature of subjecthood that is the defining character of federalism as a form of democratic constitutionalism. And I think this is what you're doing. You're actually reminding us that federalism is a discrete category of democratic constitutionalism, which theory has completely bypassed, in my view. So Waldron, like others and like his critics, paints on the canvas of a monistic demos approach to the demos. And I think what you're doing is challenging him far more fundamentally than some of the very careful sort of skewering that you do in the paper. Because, at one point you say the challenge of a federation is determining which majority or majorities should be prioritized on substantive questions. I think this goes beyond the question of the value of a legislature as an equal voice. I think you're saying, in what way is a federal legislature reflective of this different form of subjecthood? The fact that these subjects are territorial. And I think beyond that, you're actually taking us into an even deeper question, which is the very premise of constituent power in federal context. So I think you're taking us back from subjecthood to the actual a priori legitimacy of a federal democratic constitution as opposed to a unitary democratic constitution. So when you then go to a federal democratic metric as a methodology, which is a really interesting term to use, and you say you're going to stay loyal to Waldron's approach, I think in many ways you're too loyal to Waldron's approach, because I think you're going much further here. And I think you're really asking us whether either the legislature or judicial review work here in a federal context, because both are based upon an essentially individualized democratic premise. So I think what you're doing, and when you're talking about the equal voice and the multiple demoi in a federal system, you're unsettling this individualized matrix upon which the whole debate between Waldron and his critics has taken place. You're actually unsettling the default, what I call default modernist constitutionalism, which is premised upon this individualized context. This leads me then to the rights issue specifically, because I think the potential here is to become even more heretical. I think the federal ontology that you're using questions not just which institution best reflects rights within a federal system, but really the place for a Bill of Rights within a federal system at all. And whether federal constitutionalism happily can accommodate the whole notion of a Bill of Rights. The problem with the rights debate is that it's immediately thickened by an underpinning liberal ideology and hence framed in individualized terms. And at one point you use a really nice quote where you say, people do not merely wish to be able to live according to their own deeply felt moral principles, they also often wish to impose these principles upon others. And that is often where the Bill of Rights debate is taking place. It's this assumption of being correct. And then you're talking about, well, the premise of a federal system is the fact that we haven't just gone down a unitary system. It's because there isn't this fundamental agreement on values to begin with. The fact that territorial sites are left their own governments, it's precisely because those governments can then form their own value judgments within the context of the overall constitution. But the methodology, it seems to me, the constitutional methodology of a federal system is premised upon political engagement and deliberation and activity. It's not premised upon the foreclosing of values, quite the opposite. And the problem with the rights debate is not only is it thickened by a certain liberalism, and you call it centralization, and you're right to call it centralization, but it goes even further than that. It's thickened by a universalism. So the constitutional centralism that it presupposes is actually premised further back on a sort of universalist methodology of values that we should all accept, not just our constitution. And again, it seems to me that federal constitutionalism challenges that. If these rights are universal, why would we have multiple governments within one system, never mind multiple governments around the world? So those are some thoughts about that. And then the empirical work you're doing is really interesting on, because I think you are raising those big questions and you should look at them. But even when you get onto the specifics of court versus legislature, in terms of the specific issue you're looking at in the Bill of Rights, it is really interesting that you're saying the court might well be a way to go here. And I was reminded of Kelson's approach to federal constitutionalism, where he says, classically Kelson has 2 orders of rule, but he says a federal system has 3 orders of rule. It has the sub-state government, it has the central government, and it has the constitution. And he posits the constitution as this 3rd order of rule in a federal system as the kind of neutral arbiter between the two. The legislature, you could say, fits squarely within the central government branch, whereas an apex court arguably fits in Kelson's 3rd branch as above the 2 sort of protagonists in the system. So I think intuitively there's a point there that you may well be right on. I can't engage with the empirical questions you're raising because they are so interesting, and it is interesting. A lot of people do claim that courts have been the driving force of centralization. So Hoogland talks about the Supreme Court in America wreaking havoc with original design is from his book. The Australian High Court is often accused of centralised. So the Commerce Clause, the Welfare Clause, all of that. But I think your proposition is much more subtle. Like, obviously the courts have done that, but I think your point is it's not been the driving force in that. It's been much more sort of acrimony and interplay between changes in culture, changes in political attitudes, and the courts playing catch up as much as the courts driving this. So that's really, really interesting. So I think what you raised there is a whole range of really interesting empirical questions. Patricia Papelier had done quite a bit of work on that, and she came to the conclusion, which I think I'll finish on, is that they're far more likely to be centralising in systems that are societally homogenized, whereas in somewhere like Canada, and Belgium, they're less likely to be centralised. And I think that ultimately leads us to where I think you really challenge the sort of Waldron debate, which is that you're saying that underpinning all of these processes of centralisation is in fact the homogenization of attitudes within a system. So when you talk about the Senate and you talk about the fact that it's all party politics now, it's no longer territory, I think that's a bigger story about the fact that the federal idea has largely been lost within a broader system of ideology, in which all that really matters now is in many federal systems, it's not territory, but these ideologies. And that brings me to Gary Jacobson's point about constitutional identity. And is it the fact that in federal states like the US, like Germany, the constitutional identity has moved from federalism to homogenized liberal constitutionalism? And it's the same game that is played out in unitary systems. And what you're doing is throwing back at this default homogenized view of constitutionalism, the fact that there is another tradition out there. There always was another tradition out there. It's still in the text of these constitutions, but the culture has moved on beyond that. But what you're saying is no less salient for all of that. So these are just my thoughts. I'll stop there.
Thanks very much, Stephen. I'll give the floor to Neil.
Yeah, okay. Can everyone hear me okay? Yeah, okay. Thanks. Great paper, Erin. Great comment, Stephen. It's, at least some of what you said is ultimate copy. I was going to say that too. It's let me actually, pursuant to your theme, I also have a sense that some of the questions that are being asked here are even bigger than they represent themselves. You know, there's a sense in which responding to Waldron can be a little bit of a trap, you know, because I think Waldron has his blind spots, and clearly there is a blind spot there about federalism, and it's quite difficult to point out the blind spot but still kind of accept his framework and try to argue within it. There is something there which I think is it immediately puts you in a position of sort of tension with that whole way of looking at it, and that actually gets to something deeper, which I think my sense is that, you know, everyone has a blind spot here, including you, right? I think everyone has a blind spot in this debate, and it seems to me that clearly Waldron's blind spot is the reality, the lived reality of multi-level governance or federalism, whatever it is you want to call it. What he's interested in is the reconciliation of rights and unitary democracy, right? And he thinks he's found a way of doing this. He's not dismissive of rights, but he thinks he's found a way of doing this which, you know, frames rights within the kind of legislative process, etc., etc. In many ways, his whole academic career has been about trying to achieve that reconciliation. And you come along and say, well, what about federalism? Now, the cheap answer to the federalism argument is that federalism has a blind spot about democracy, right? And it may actually have a blind spot about rights. And here actually I'm reminded of, and try and bear this metaphor in mind as we go through Danny Roderick's argument about globalization, you know, the paradox of globalization, that there's three desiderata. We can only ever have two of them. You know, we can either have democracy, we can have democracy and globalization and what he calls nationalism, but all he means by that is identity affirmation, right? Said we can have two out of the three of these, but we find it very, very difficult to have all three. You know, we can have democracy and globalization, but we have to give up in nationalism because it'll be global democracy. We can have, you know, democracy and nationalism, but then we have to give up in globalization, and the same applies for the third one. Now, there's a sense in which, and I don't think this is a zero-sum game, I really don't. I think it's a complex positive-sum game. I think the relationship between federalism, rights, and democracy is also problematic in that sense. That there's a way in which some of the relationships between these things are positive, but some of them are not. And that's the complexity of it, to try to work that out. So the reason why I started with that was, I guess, when I looked at your revised the federal democratic matrix, and this, you know, which I think you said it very, very well. You say, rather than asking which institutions, the legislature or court, give equal voice and equal decisional authority to individuals within a single demos, the question shifts to which institution is able to give equal voice and equal decisional authority to the multiple demo in the federal system. So behind that, there's a sense in which basically all that Waldron is interested in is the individual, okay? And he forgets about the collective. But of course, that's not quite true. You know, he's very interested in the collective, but it's a unitary collective, it's a single collective. So basically, if you see the kind of, what I see as the problematic of modern democratic constitutionalism, the deep problematic of modern democratic constitutionalism is how do we reconcile two forms of modern autonomy? One is collective autonomy, and the other is individual autonomy. And for me, the heartbeat of democracy is about the terms and limits of that reconciliation. So when we talk about the relationship between democracy and rights, that's what we're trying to do. We're trying to find the balance. We're trying to find the optimal balance between these different sorts of ideas. And equally with federalism, we're building into that the fact that we have multiple democratic identities, etc., etc. So all of this is in the mix. Now, I think the danger with the way that you talk about it is that it can become indistinguishable from more general problems of balancing within multi-level government. So if I said to you, okay, let's take something which is palpably democratic, well, palpably at least partly democratic like a state, and something which is either less democratic like the EU, or not at all democratic like the UN, or only very, very indirectly democratic. And I ask you to think of a way in terms of multi-level governance to balance the accommodation of rights between these different sorts of levels, then how would that look different than your federal democratic matrix here? How would that look different? Because what you're doing within this is that you're immediately taking it to the collective level. And yes, you're saying they're democratic, but all the emphasis, all the oomph within it goes into the relationship between the two entities and the optimal balance between the two entities. And there's a sense that you come so far downstream of the original individuals within these entities, it's not at all clear that this is any longer a debate which is taking place within a democratic matrix, as opposed to just a multi-level matrix or a federal matrix in the way that, as is often said within the origins of federalism is an idea which is older than democracy. And we know why. Because in many ways, federalism works, in some ways it works better without having too much democratic DNA built into it. So the danger is that you throw the kind of the baby out with the bathwater. That what in attempting to correct the individualism or the excessive individualism of something like Waldron, you end up with a kind of excessive collectivism. Now, I think your position is much more nuanced than that. But that's where I come back to the Roderick point, right? That there's a constant tension between these sorts of ideas. In fact, when I read the paper at first, I thought, there's another way of actually, arguing this and saying that actually, if what you want to defend is a position for the courts, within a federal system, as the final adjudicator on rights rather than the legislature, then yes, actually, there's a very, very good argument for that. But it's an argument which actually leads towards centralism, right? It's not an argument which, so the idea that somehow, the institutional solution should be to the problem of over-centralization is predicated on the idea that if you put together democracy, federalism, and rights, then the answer should be quite a decentralized one, right? You might say that actually, the ideal for, and I think in a way Stephen might have been hinting that as well, that if you actually end up with a court in that sort of situation, then you are going to get quite a lot of arguments about rights universalism. A lot of that is going to come to the fore. There's two things. There's an empirical argument about when it does come to the fore. There's also the moral argument about whether if you embrace rights in that sense, you probably should. You might end up very, very much in a direction of a more centralized form of federalism, maybe a more workable form of federalism, but one which, led to a greater degree of centralization. In other words, the argument, the institutional argument, which you have, which is about putting courts at the centre, rather than political institutions, might be the optimal answer, but maybe not the optimal answer for the reasons that you want it to be, because it can actually lead towards a more centralized solution. Not because you're wrong in some fundamental sense, but because there's always this constant trade-off between these three different variables. So that's part of that's the main, my main sense of this, that basically what this needs is more kind of excavation work, on what is the fundamental relationship between what I see as three different values, and the signal contribution, not the single, the signal contribution you've made here is actually bringing that third variable into play. Quickly on the empirical question, and again, like Stephen, I thought this was really, really interesting. It's also a really underdeveloped part of the paper. I felt, that I actually had to read that paragraph or two very, very hard to get the jewels out of it. The point about path dependency of legal decisions, which is a good point, but the broader point about legitimacy, which actually also goes to my theoretical point, because there is an open empirical question about whether putting courts in the centre does or does not have that kind of effect. And on the side of your argument, there was a couple of things I thought. One was that the way that you introduce a legitimacy point is actually quite defensive. It's like the court is searching for a position of legitimacy, that by default it doesn't have. And of course, it reminded me of a very the stark alternative to that would be someone like Alex Stone-Sweet. So when he looks at courts in these multi-level systems, he sees courts as sniffing these opportunities, saying, "Oh, come on, no institution within this multi-level complex has obvious authority. Therefore, here's an opportunity, and if we as one of France's four, Supreme Courts at the national level, want to optimize our voice and optimize our authority, well, let's go along with what the European Court of Human Rights says, or what the European Court of Justice says, or whatever it might be." So actually within these systems where there's quite a radical fragmentation of authority, it's often about courts or other institutions finding friends somewhere within that multi-level framework where they can end up finding common cause and making themselves central to a particular political program or a political mandate. Because remember also, from the point of view of courts, it's not just about legitimacy in some abstract sense. It's not just about, Boris Johnson trying to remain legitimate by whatever it means, and whether it involves cuddling Joe Biden or not, it's also, some of these people also sort of believe in rights, don't they? And they think, okay, how do we actually push this agenda as hard as possible? And one of the ways they do that is to break bread with other institutions and to find some sort of common cause there. So I do think actually, and I know now I'm sort of arguing against my own initial premise, but I think more can be said about the ways within fluid multi-level systems that courts can do this kind of work. But let me just say in conclusion that, I really, really enjoyed this paper. I thought I confess I sat down to read it this morning for the first time, and I ended up reading it twice because it's a very complex paper, and I'm now going to go away and read it for a third time. So thank you.
Thanks very much, Neil, also for your comments. I think, first of all, we'll give the floor back to Erin for if you'd like to kind of react or respond to the comments you received.
Yes, I will take a couple minutes to respond and throw some more things out on the table, and then I look forward to our group conversation. First of all, thank you both very much. Those were very helpful comments, and I want to just respond a minute to Stephen. I think that you're writing the book that's going to solve all of these questions, right? This is your upcoming book on federalism and constitutionalism, isn't it? So I'm hoping. Well, I'm not so sure about
solving problems. But yeah, I think that this is a new area. You're absolutely hitting on a new area.
But you're right in that it is underdeveloped, and I think some of Neil's responses tied into the frustration about that underdevelopedness of it and the tension of how, I was just at this event, but Mark Tushnet is retiring, and he's having just this never-ending series of palooza-thon, festschrifty things. And I was at one where we were talking about, the many adjectival constitutionalisms that exist in the field right now, authoritarian constitutionalism, all these different ideas. And one of them is, that has not been articulated is federal constitutionalism. And is that meaningfully different in a way? And how do we conceptualize that? So I appreciate that and look forward to reading your book. Your comment about the best way to mediate this tension of complex democracy, federalism, rights as being through kind of a political process, I think gets to what I am actually more interested in, which is the conclusion or the idea of federal systems that are outside of this core, that present the messiness that Neil identified, where in fact the court is baked into the federal design. So you are having some of that assumptions that, Neil, you were talking about what the role of the court is supposed to do in the society. And then what does it mean to balance the individual and the collective autonomies? And so one thought I have from the American context is really, how do you construct individual exit from collective autonomy? And who's best at doing that kind of construction? So you think about the Canadian examples. What do you do when an individual in an Indigenous community actually makes a claim on gender discrimination grounds? You see this in the United States when you think about some of the tribal commitments to collective property that go against individual property rights commitments in the US construct. How does that exit get structured, and who can think about it? And I think one of the answers in the Canadian literature is, well, more deliberative democracy, but that doesn't work if you're always a minority. Just talking about it more isn't necessarily going to give you any more collective rights. And what you end up seeing is the minority within the minority that connects with the national majority, maybe getting rights in a way that can undermine the subnational collectivity. So I think that this is the area, as we think about legislatures and courts, where courts have been kind of undervalued in their ability to construct exit. And it's an area in U.S. con law that's actually, ironically, because he probably doesn't even know that he was doing it, but is typified by Justice Kennedy's jurisprudence, where he's thinking about levels of governance and at what level, in a case like Romer, which is a case about whether or not a state can prohibit the protection of gays and lesbians by cities within that state, right? If you can have a constitutional referendum at the state level foreclosing the ability of people to succeed at the local level in protecting themselves. And he says, no, he says the state is too big a level to do that, but it might be acceptable at a city level. And so just this idea of where can you exit, where can rights vary in a way that imposes upon your individual rights, but reflects other kinds of collective rights, a religious-based right, maybe in that example. How do you weigh that? And that's something that I think has maybe less relevant in the United States because of the homogenization that we've all been talking about, but clearly is relevant in federal systems where you have subnational majorities structured in territorial regions, particularly when you get into thinking about Indigenous groups with different kinds of legal systems and different kinds of approaches to collectivity. So I think that that's very much sort of the way, part of where the conversation needs to go as you think about this. And Neil, your point about Europe, I think about Calypso's work on democracy, which I've been talking about to Americans. They think they love the pun. Americans love a pun. But I think there's a lot of interesting European work that has been done to break outside of the strictures of federation in the EU, but that maybe now should be brought back in to thinking about federation. We don't need to let Weir and some of the classical federalists control the narrative any longer. And we could actually think about, what is different about federation or federalism? What is the distinction between multi-level governance, federalism, and the role of democracy in these different levels? And how do we think about them? How do we think about that? And then finally, the point about the court, I think you are very right that I wrote that too quickly, because my baseline assumption is that the court is going to be acting to take advantage of the opportunities it presents that are presented to it, especially in a federal system. And that is, I think, how courts end up being extremely powerful, is that multiplicity of options for constructing judicial power. This is the piece that I wrote a long time ago when I was visiting you in Edinburgh about how I think that it's the federalism questions that will drive the UK Supreme Court's expanding authority, or could at least drive it. And so my point about the legitimacy issue is just that that's a dangerous game, because at the same time that you're doing that, there are a lot more people to upset. And that if you do something that engenders non-compliance by a subnational unit, and the federal government is not willing to go in, or the national government is not willing to go in some way, send the troops to Arkansas, then you're in trouble. And then the court is undermined. And you see this in the United States in very interesting ways. School prayer, right? We're not supposed to have prayer at public school. If you go to the South and you go to a football game on Friday night, there's prayer. So, where does that kind of undermining of Supreme Court decision-making happening, where there's an unwillingness for the federal government to ensure that they're not sending troops to every high school football game in Texas? That's just not happening. So that is you see some of that, the questions about what rights can be effectively implemented through the judicial system are the rights that end up getting enforced or that end up getting prioritized, right? It's, and this came out in the same-sex marriage debate about whether or not an individual would issue the marriage certificate. But you see this bubbling up, and I think it does affect the court's understanding of its own capacity and the dangers in this kind of a system of meaningful opposition and continued opposition through subnational autonomy in these different regions. So I will stop there, but there's a lot to think about.
Can I...